Your Lordship, I'm mentioning upon notice there is a withdrawal of an application. If it could be kept in the to be mentioned tomorrow in this monthly list 369.
Your Lordship, may I be allowed to mention one matter? My Lord, this matter is pending since so long. Petitioner is suffering. I'm praying for an upgradation because my Lord, the award has already been passed and we are now seeking for final execution, my Lord. Kindly take this matter in the day.
Not right now. 34 petition.
Yes, my Lord, I'm for.
Not right.
Lordship, kindly allow me one. My Lord, the petitioner is suffering from severe financial losses, my Lord. The award has already been passed.
Matter will come in due course of time.
Lordship, may I be permitted to mention a matter for upgradation? Lordship, it's appearing as item number 729 in the monthly list. This is an Lordship, this is an execution application. Lordship, earlier there was an appeal pending by way of which
Coming up, madam, it will come in due course.
I may have Lordship kindly to mention, my lord, but item number 228 of your Lordship's list. My lord, there is a one application, an opposed application, but I'm in default of filing an affidavit in opposition to the section 34 application. Another application in the section 34 application, we filed a G, but I'm an award holder of 80 crores and above. But I want to withdraw the money after giving us security. But urgency is that only for apart from recovery of money, I'm not getting the awarded sum by giving the security. But sooner the better.
Move an application.
I have already
Application is there.
But one is innocuous application, as I told you, for putting in the affidavit in opposition after finding that I'm in default. That is one application that the Lordship has permitted. The other one is
My Lord, I have got a section 26 application. In that matter, His Lordship, Miss Justice Sampar Sarkar passed an order for release depositing 2 lakhs of rupees to the registrar in cash and residue 2 lakhs of rupees by demand draft. That has been done. I am only praying for withdrawal of the money by putting a security.
Move an application. Application you move.
Application is filed in 2024.
Yes. Yes. Sir. Yes. Yes.
Award has been challenged by the respondent before the district judge at Alipur. And I had the occasion of listening to this matter once. The maintenance point was being decided, and one of the matter is returnable in the district court, the Alipur, on 22nd of July. It is appearing as item number 311 in the monthly list.
It will come up in due course. We'll see. 34 petition. No upgradation. Right?
Your Lordship, may I crave leave to mention a matter, section 11 matter, Your Lordship, for inclusion.
To mention a matter for it's under section 34, my Lordship, for inclusion.
Upgradation not possible.
No, my Lordship, for inclusion.
Inclusion.
Lordship, I say for listing of item number 805 and 806.
What are those matters?
Lordship, these are execution petitions.
It will come in due course.
Lordship, just a second. Yes. Lordship, serious fraud has been played on this court and it was highlighted on the last occasion also. More than a year has passed, it has not come up.
We'll
Lordship will be very surprised to see the fraud on this court.
We'll see that. Let it come in due course. Yes.
I am permitted to mention, Your Lordship, on 9 July, Your Lordship was pleased to attach the bank accounts of award debtors in terms of Your Lordship para 8 of affidavit of assets. Inadvertently, Your Lordship, I find that in the order sheet only one bank account is attached. However, in the affidavit of assets, there were 3 bank accounts, Your Lordship. So I brought the affidavit of assets in order also, Your Lordship. Make kindly peruse.
To be mentioned.
Oblige, Your Lordship.
May I be permitted to mention, my Lord, my application under section 29A, my Lord, for inclusion.
In 29A.
My Lord, may I be permitted to mention for upgradation, my Lord, section 36 application. My Lord, the other side, opposite party has already filed the execution application before the Honorable Bombay High Court. The matter is fixed on 27th July. My Lord has heard this matter. My Lord is directed for filing of the documents that has been filed before the learned arbitrator, my Lord. If your Lordship kindly give some precedence, my Lord.
When is it listed before execution court?
27th July, my Lord.
This is your 36 application.
36, we have filed.
Mentioned other side. Where's the other
Yes,
side?
my Lord, I am giving notice through email. I have informed them, my Lord.
All right, do it.
36. Grateful, my lord.
Lord, may Lordship Lord, mention for inclusion, Lordship, earlier also, my Lord, before vacation.
Inclusion of 34.
23 matter, Lordship.
23 matters.
Yes, Lordship.
What are these matters?
Section 34, 23 matters, my Lord. I am, my Lord, suffering 1 crore 10 lakhs, my Lord, since, my Lord, 2012. My Lord, regarding a construction of a building, Lordship, I have given a notice, my Lord. And if
Notice you have given?
yes, yes. If your Lordship, my Lord, fix a date, my Lord, I shall
No date can be
intimate.
fixed. Inclusion means only inclusion. We'll see when it comes. Put in the list.
Listed matter. New motion section 29 item number 1.
My lord, I appear for the petitioner, my lord. This is a section 29A application which my lord lordship was pleased to direct affidavits. In the meantime, parties, my lord, discussed and they have now agreed to settle. My lord, the MOU is also drafted. I am only to receive the money, my lord, that has not been done. So what we were praying, my lord, subject to lordship's approval, kindly keeps it monthly list of August. By this time, my lord, I expect the payment to be released. We can come with the terms of settlement.
Let it be in the monthly list of August.
All right. Learned counsel for the party. State that the matter has been amicably settled between the parties. Say that the learned counsel for the party submit that amicable settlements are underway. Also, they pray for an adjournment. Let this matter be listed in the monthly list of August, with liberty to the parties to mention in case the matter is resolved between the parties on an earlier date.
Very grateful, my lord. Leave it.
Please.
So, my lord, my application under section 29A,
Yes.
my lord, on June 15 was pleased to direct filing of affidavits.
Yes.
My lord, affidavit in opposition was received only yesterday, my lord, yesterday afternoon by email. I was filling a fortnight's time to put in my reply, my lord.
Well, I have something to say. I don't want to take my friend by surprise at all. Of course, my friend is right. There is a delay. Some of it is on our part, and the other is because the cause title, with great respect, has been wrongly put. It's the earlier name of the company. Therefore, an amendment application has been affirmed. But if your lordships allow the amendment today, Malad, then I think the application would not be required. The arbitral award itself records the change in name. But unfortunately, in the petition filed before your lordship, the earlier name has been used, which is why it couldn't be.
He has moved the amendment application.
No, Malad, we have moved it because otherwise we were not able to affirm even the affidavit in reply, in opposition.
The application on record.
No, it's not on record.
It's not on record.
It's not on record. It's been affirmed only.
How can I allow it?
I'm so sorry, Malad. We'll police it.
On Wednesday, my lord can keep both the matters together and pass.
If instead of Wednesday, may I request for Thursday, Malad?
Okay, my lord.
Thursday not
Thursday is
possible.
not possible.
Very well. If
Where's the affidavit in opposition?
I am carrying copies of it.
Affidavit in opposition filed by the respondent is taken on record.
You've preserved the Malad.
Learned counsel for the petitioner seeks and is granted 2 weeks time to file her reply to the affidavit in opposition.
Malad, I'm sorry to interrupt your lordship. I thought I could put an end to this matter. There's a judgment of your lordship's High Court itself on this issue, on a legal issue. If I can place that judgment, I can.
There is a Supreme Court judgment which I will again rely on.
No, the Supreme Court judgment.
2-volume.
Whatever it
I'll
is,
just
let-
make one sentence and I'll stay there. I just wanted to say the Supreme Court judgment that my friend is relying on is on the fact that 29A can happen after the award. There's no quarrel with that at all.
I'm relying on another judgment
Very-
regarding
then I'll
this section also, my lord.
I've
Subsequent to
examined the law, Malad. I didn't think there was any, but I'll wait.
there is, my lord.
Very well, I'll wait there.
2 weeks time to file her list on. After 2 weeks.
After 2 weeks.
Great.
I'm very grateful.
The decline like learned counsel for the petitioner states that she has received the affidavit petition yesterday. She prays for 2 weeks time to file her reply to the said affidavit in opposition. List.
Malad, the amendment will also be taken up the same day.
Where it gets listed?
Very good.
Not there today on the record.
Your lordship, I'm so sorry.
I do not 3.
My lord, with your lordship, leave me appear online, my lord.
Yes,
My lord, yes, my lord, this is my section 29A, my lord. This is my second extension, my lord. The arbitrator is
on the other
proceeding.
side. The
My
half
lord,
goes on the other side.
yes, my lord, we had tried twice to serve them, my lord, but they are not, my lord, the affidavit of service is coming that address is left, my lord.
You have to
We
get
have-
the address.
My lord, it's going ex parte, my lord, it's my, pleases, otherwise we have to take other steps to serve, my lord.
Service you have to do. Can't be
Then, my lord, kindly gives us a direction for paper publication, my lord, will come over after that, my lord.
Learned counsel for the petitioner states that despite best efforts, the service could not be completed. Then the service report indicates that the addressee has left without instruction. Praise for substituted service. Let the service be done through paper publication. The paper publication shall be done one commercial and one vernacular within a period of how much time?
My lord, 15 days, my lord.
Within a period of 2 weeks. Just after
My lord, please is to give a date, my lord, then we'll put it in the paper, my lord,
Give
that
after
on
3
that date.
After 3
Much obliged, my lord.
affidavits.
Grateful, my lord.
Four.
My lord, I appear for the petitioner, my lord. This is an application under section 29A, my lord. It will be the third extension, but my lord, we were informed that the award is on the verge of being ready. So, my lord, perhaps a month's time would suffice, my lord.
Where's the first extension?
My lord, the first extension,
last
my lord,
one?
was on
The
20.
last one.
The last one, my lord, was on 3rd of February, my lord.
Page.
Paragraph 23, my lord.
Page.
It's annexure G. Just gives me a moment, my lord. It's at page 35 of my application.
15 December.
My lord, it was due, no, it's 3rd of February, my lord. Page 35 of my application. It was for a period of 3 months, which was due to
All right, take
start.
The petitioner has preferred the present petition under section 29A of the Arbitration Conciliation Act, seeking extension of the mandate of the arbitral tribunal for publication of the award, right? It has been concluded.
Yeah, concluded.
Publication
It's been a while, my lord.
full stop. This court, by order dated 15 December 2022, had appointed the sole arbitrator to adjudicate the dispute between the parties. Full stop. This court, by order dated 1st May 2025, and only one order by this court, right?
My lord, two orders. One was of 2025, my lord,
3rd February.
and 3rd February.
1st May 2025 and 3rd February 2026 had extended the mandate of the arbitral tribunal by 8 months, and the second one was
For a period of 3 months,
8
my lord.
months and 3 months respectively. Full stop. Learned counsel for the parties submit that the matter has been concluded and is due for publication of the award. Full stop. Learned counsel for the respondent states that he has no objection to the present application. Full stop.
Statutory authority, I don't have any written.
Oh, statutory authority. All right. No need. No. Yeah, no need. It's a quota. Upon consideration of the materials placed on record, this court is satisfied that there has been no delay on part of the learned sole arbitrator in conducting the arbitral proceeding. Full stop. Having regard to the advanced stage of the arbitral proceedings and the interest of justice, the mandate of the arbitral tribunal is further extended for a period of 2 months.
My lord,
2 months from today. The learned arbitrator is requested to make all reasonable endeavors to publish the award within the extended time period. with the aforesaid direction, the present petition stands.
My lord, my affidavit of service may be kept.
Affidavit of service taken after court.
Great.
Item number 5.
Time for the respondent.
I appear on behalf of the petitioner. My application under section 11, Lordship, for appointment of arbitrator arising out of a partnership agreement. Your Lordship, they filed a suit seeking a declaration that the agreement itself is void. Your Lordship, in that suit, I have filed an application under section 8 of the Arbitration Act, which is pending for adjudication. It's appearing today in the list as well. Lordship has been adjourning this matter so that the section 8 can be decided. So, subject to your Lordship's.
Can that be decided?
Yes.
Lordship, may I only request, instead of keeping in the next monthly list, if your Lordship can keep it in September's monthly list so that we have time to get it adjudicated.
In the food court, primarily the adjournment is being sought by my land. Kindly keep this matter in the next monthly list so that
Very well,
we
Lordship.
ourselves have some motivation to finish the matter before.
Very well, Lordship.
Take that. Learned counsel for the parties submit that section 5 and section 8 proceedings are pending before the coordinate bench of this court. They pray for a short adjournment to await the outcome of the said proceedings. List in the monthly list of August.
Grateful, Lordship.
Yes. Item number 6.
And for the respondent. But is arising out of suit filed by me.
Who's on the other side? Where's the petitioner? Here, Nurul. Mr. Arfin was appearing. He's not here.
Will be connected to the application where the filed an 8 order which has.
All right, none for the petitioner. Learned counsel for the respondent states that the revision petition is still pending before the coordinate bench of this court. Let this matter be listed in the monthly list of August.
Seven.
Well, we were exploring the possibility of a settlement, and my lord, progress had been made, but then the government changed. So, my lord, now, my lord, we have to await formal, my lord, directions from, my lord, the new incumbents regarding the settlement. So, my lord,
Section 11 and the section
one
9.
section 9 and section 11. Well, if it's settled, it is settled. Well, I'll request your lordship only for 3 weeks' time. Not settled by them, we'll do the matter.
And for the respondent.
Point number 1 would be government, I guess.
Well, the response number 1 is the state housing board, West Bengal Housing Board.
Who's appearing for that? Nobody's here. Probably they might not have nominated somebody as the council. Should I record that settlement talks were going on?
Yes, yes.
Yes, yes. Well, that
Learned counsel for the petitioner states that settlement talks were underway. Full stop. Though he further states that there has been a change in the government and he seeks an adjournment. Let this matter be listed after 4 weeks.
well,
I appear for the petitioner, my lord.
I'm for the response number 1 housing board. Housing.
So you are appearing for the respondent.
Yes, well, the housing board.
All right.
I appear for the petitioner.
Okay.
There's an interim order in the section 9 application. Kindly extend that for a period of 4 weeks.
Section 9. Section 9 दिखा. So if you are appearing for the housing board, then you get continued.
I can continue, my lord, but housing board is trying to settle the matter.
All right.
My lord,
In that case, then I'll also change. Learned counsel for the petitioner, learned counsel for the parties state that settlement talks are underway. They pray for an adjournment. Let this matter be adjourned for a period of 4 weeks. Section 9, yes.
It becomes 699 of it. Last 10 on 15.
Section 9 then, no?
699.
Extended by 12 weeks more on 15 June 2026.
The interim order granted earlier, which has been extended from time to time, is further extended for a period of 12 weeks.
yes, sir.
For a period of 12 weeks. List in the monthly list. I'll put it in the monthly list.
Yes, ma'am.
Month.
My lord,
September.
12 weeks उसमें भी दे दो section 11.
may,
List after 12 weeks.
I only request 12 weeks or until further order. Well, in case there is no settlement,
12 weeks or until further.
grateful.
List in the monthly list, dono. Both. Monthly list of September. September. Monthly list of September.
Appearance को लिखो.
दोनों except. ठीक है, and 12 weeks in both.
I know 9.
Lord, I appear in this, beg to appear in this matter, my lords. For the petitioner.
Yes.
My lords, in this matter, as per, this is an application for appointment under section 11 of an
Who's on the
arbitrator.
other side?
My lord, I informed the other side, Mr. Banerjee is appearing. If I called him up also.
Last time he was here.
No,
No.
my lord, last several times he has not been there, my lords. In fact, there is no quarrel on the appointment. They also agree that an arbitrator should be appointed as per their reply.
I'll pass it over, you call him.
Whatever,
So
lord.
pass over may be difficult than your lordship.
Tomorrow then. Not today, tomorrow.
I'm grateful.
Day after. Day
Tomorrow,
after.
tomorrow, your lordship.
Not tomorrow. Tomorrow is Tuesday.
Very well. Day after, I'm grateful.
My lord, let it retain its position.
I know 10.
My lord, this is my section 11, my lord, and item 11 is their section 9. My lord, the parties have reached upon a settlement, my lord. They're in the middle of finalizing the terms of settlement.
I've also been instructed by my client that talks of settlement are on.
My lord, may I pray that the matter may be kept after 12 weeks, my lord.
Learned counsel for the parties submit that settlement talks are underway. Both the parties jointly pray for an adjournment. Let this matter be listed in the monthly list of September.
Yes, my lord.
Monthly list of September.
Grateful, my lord.
Yeah, appearance.
Same order कर लेना both the matters. One is 9, one is 11.
I know 12.
Item 12. Item. Lordship, this I'm appearing for the petitioner. Matter has been settled between the parties. Amount has been repaid. We have given no due certificate.
Learned counsel for the petitioner seeks to withdraw the present petition. Same as dismissed and withdrawn. Yes, sir.
My lord, may I hand over the note certificate for records
Notice of?
that we have given to the borrower that the matter has been settled?
I'm not recording it. I'm simply
Okay.
just dismiss as withdraw.
Lord.
Now 13.
This is my application. I am led by Mr. Rajesh Sharma, learned senior advocate.
My lord, in this matter, I am appearing on behalf of R1, my lord. My lord, we don't have any objection on the appointment of the arbitrator, my lord. If my lords may
for the
kindly
petitioner?
permit, we'll
Who's for the petitioner, sir?
I am for the petition.
You're for the petitioner?
Yes, sir.
He doesn't have any objection. R1.
Well,
Who's
due to
R1?
interim
if
award
my
already
may,
been passed. Interim award already been passed by the learned arbitrator, and thereafter demise of the learned arbitrator, I am praying for appointment of an arbitrator, my lord. As a retired judge, any retired judge of this honorable court.
if my lords may kindly permit, my lord, we can suggest two names of the retired High Court judges, my lord.
You have filed a section 11.
Yes, my lord.
Arbitrator has already been appointed. You want a change in the arbitrator because the earlier one has demised.
Due to
You have to move an application under 14 or 15. How can this be maintainable? It's not maintainable.
my lord, give me
How section 11 maintainable, sir?
my lord, give me liberty to hear and out, my lord, to make it correction
No,
because
it can't be. Sorry, sir.
on
I'm
the
not
la-
going to give you liberty to change the sections like this. You withdraw this, file an appropriate proceeding.
my lord,
You
on
want me
the
to
last
dismiss it? I'll
occasion,
dismiss it.
on the last occasion,
Section
my lord,
11 is not maintainable. I told you last time also, I told you this.
on the last occasion, my lord pointed out, my lord, this is
I pointed it out that section 11 is not maintainable. File an appropriate proceedings in accordance with law, which will be section 14, 15 application for change of the arbitrator.
your lordship pleasure, but it may be corrected, my lord.
No, sir, it can't be corrected. Sorry.
If my lord say, my
No,
lord,
sir, it can't be corrected. A petition of section 11 cannot be converted into section 14 and 15. Sorry.
liberty may be given, that's why, my
Liberty
lord,
can be given to file the appropriate proceedings in accordance with law. No,
your
you
lord.
withdraw this and file appropriate proceedings. Learned counsel for the petition seeks to withdraw the present proceeding. Present petition, the same is dismissed as withdrawn with liberty to file appropriate proceedings in accordance with law. Arbitrator has already been appointed. How can section 11 petition be made?
Interim award already been passed, that's why
That's why I'm saying that you have to move appropriate application, sir.
as your lordship. Obliged to Lord.
Not I am
I'm
pleasing. It's what the section says.
Section 14.
14.
I appear for the petitioner.
Learned
The
counsel
direction
for
was given on 15th of June. Well, a week's time will be given to file my reply. That
Learned counsel for the respondent states that she will be filing the affidavit in opposition during the course of the day. During the course of the day. I'll give you 2 days time. Learned counsel for the respondent seeks and is granted further 1 week time to file her affidavit in opposition. Reply to the same, if any, within 1 week thereafter, left after 2 weeks.
gratefully, Lord.
My lord, this is my application under section 11. On the previous date, we had served, but the item was hold and intimation was served. Now we have served afresh as per my lord's directions. Thereafter, we have also served by hand. I'm filing, that was successful. I'm filing the affidavit of service as well as the copy of the cover letter. That's it.
Or have you given the service?
My lord, in the we have not yet filed an affidavit with regard. We have given hand service. I've served filed the cover letter, copy of cover letter along with.
File an affidavit of service, sir.
My lord, affidavit of service was affirmed beforehand. We have done subsequently last Friday.
File a fresh affidavit of service. This can't be done.
As my lord, please.
Done and transfer for the petitioner, seeks and is granted further time of 2 weeks to file his affidavit of service. Best after.
Much okay.
6 weeks.
Milord, Milord, this is my application on the section 11. On the last occasion, Milord, I had handed over an affidavit of service. It could not be delivered because the speed post had come back undelivered saying that there's no addressee. We have now served again and we have used the courier services, Blue Dart and DTDC. Courier service of Blue Dart, 3 times we made an attempt. Now they are returning to say consignee refused to accept. I have the affidavit of service. The only difficulty is the person concerned is stuck in traffic. If your lordship kindly passes it over, then I will affirm and come back
Day
to you.
after tomorrow.
Very well.
Day after tomorrow.
Very well.
$70.
To this point, the last time when the petitioner appeared here, we sought for time for a week. I believe that was on 10th of July. There's a resolution on
What resolution?
I believe there's a resolution which has come out not to appear.
So Banerjee, is there any resolution?
For the resolution is not to request the learned judges not to take up any matter and or not to pass any adverse order in the absence of both
When did it
parties.
It's not.
Yes,
Not okay.
so, Malad wasn't.
No, I'm not.
Malad, I can just once Malad, I can just. Malad, it says in view of the untimely and unfortunate demise of Mr. Ikshita Banerjee, sons and learned advocate member, request is made to the honorable judges not to take up matters from 10:30 a.m. and not pass adverse orders in the absence of both the sides, and to rise at 3:30 p.m. in view of the joint decision of the honorable judges. So that's the.
None for the petition in terms of the resolution passed by the court. Matter be listed or not today. Girl. I'll make it not today. We'll have it on Wednesday. Not today.
Great.
Item number 18.
Lordship, pleasure to take it up tomorrow. 18.
Not today.
So the issue of jurisdiction 18, 19 and 21. But there was an issue of jurisdiction.
We take all the 3 matters. 18, 19, 21. Not today.
Wait.
21.
Item number 20.
Not today.
$22.
22.
But I appear for the petitioner.
My lord, the only objection I took was, my lord, that the in-house mechanism was not done, my lord, but lordship said now that there are disputes, lordship will pass an order. Anybody, my lord?
This is my affidavit.
The same matter, right?
Yes, last day, lordship, my lord, this was the last matter, lordship, with my lord, section 11.
Yes, yes, yes.
Lord, page 13 is the agreement.
Page 13 is the agreement.
And the arbitration clause with the page
18.
18, my lord.
Clause
yes,
27.
And the notice of invocation is, my lord, at page
19.
19, 18th May 2026. kindly keep all points open, my lord. Whatever, my lord, points I have to take, my lord, before the
Take down. The petitioner has preferred the present application under section 11(6) of the Arbitration Constitution Act 1996 seeking appointment of a sole arbitrator to adjudicate the dispute and differences alleged to have arisen between the parties out of and in connection with the unregistered lease deed dated 12/3/2015. It learned counsel for the petitioner submits that they are the absolute owners of the shop room measuring 898 square feet situated on the ground floor of premises known as Sushila Nikita, holding number 17/727, premises number AF377, Krishnapur, Hanapara. Krishnapur, Hanapara, Bagoti, Calcutta. According to the petitioners, the said premises was being used for commercial purposes with a view to letting out the same. The petitioner had entered into a lease deed dated 12/3/2015 with the respondent, whereby the petitioners were the lessor and the respondent were inducted as the lessor. Under the terms of the lease, the respondents were granted tenancy in respect of the said premises for a period of 3 years, commencing from 17/4/2015, with an option for renewal for 2 successive terms of 3 years each. The monthly rent was fixed at 70,000, together with maintenance charges of ₹700 per month towards the common toilet and passage. The respondent had deposited 2,10,000 as security, equivalent to 3 months' rent. It is the case of the petitioner that the respondent initially paid rent for a limited period, thereafter became irregular in payment, and ultimately committed defaults in payment of the lease rent, maintenance charges, and other contractual dues. According to the petitioner, despite repeated requests and reminders, the respondent neither regularized the outstanding payment nor vacated the premises, thereby continuing in occupation of the said premises without paying any consideration. The petitioner contends that since the monthly rent payable was ₹70,000, the tenancy stands excluded from the provision of the West Bengal Premises Tenancy Act by virtue of Section 3 thereof, and the relationship between the parties are governed by the contractual terms. Learned counsel for the respondent states that he admits the lease deed entered into between the parties. He does not dispute to the agreement as well as the arbitration clause as contained in the said agreement. The parties,
one more submission, there may be
all issues will be left open. The parties have mutually consented to the arbitration agreement, to the appointment of the arbitrator. Mr. Give a name. The parties have suggested the name of Mr.
Mr. Anuj Singh can be appointed.
Mr. Anuj Singh as the sole arbitrator to adjudicate the dispute between the parties. In view of the said suggestion, this court appoints Mr. Anuj Singh as the learned sole arbitrator to adjudicate the dispute and differences between the parties. The arbitrator shall enter reference upon furnishing disclosure in terms of Section 12 of the Arbitration Conciliation Act. All contentions of the parties on merit, including questions relating to maintainability or arbitrability of individual claims, differences, so and so, shall be left open to the arbitrator to be adjudicated upon. The remuneration shall be fixed in terms of the fortune.
I've given the particulars of one of the loan.
About us, बस perfect. फिर केस वाला छोड़ देना क्योंकि कंसेंट से वो छोड़ दो बस मेंटेनेबिलिटी डाल दो because they have consented to the appointment.
And not 23.
This is my application under
For the respondent.
Yes.
and this is my application under section 11 and 15. My lord, there was a previous arbitrator who was appointed midway through the arbitration for his own reasons. My lord, the arbitrator has recused himself and has, my lord, therefore I am before the court for appointment of a new arbitrator. My lord,
I
there
don't
is.
have any problem, Lordship, if a senior advocate has been appointed as the learned.
My lord, may I indicate, my lord, the previous appointment order is at page 51 of my application.
Because Lordship, it's in the midway of a process, Lordship, so it has to be done.
At page 51 is the previous appointment order. The appointment was made on 27th of August 2024. After the appointment, the sittings were held on and from 10th of September 2024. My lord, there were 20 sittings which were held. On the 21st sitting, my lord, I have annexed all the minutes of the meeting. That is from page 54 onwards. Presently, it was at the stage of cross-examination of the claimant's witness. At that stage, on the 21st sitting, 21st sitting on 20th of May, this was held on, and this is the minutes is at page 99, my lord.
This is the last one.
That's the last minutes. In the last minutes, the learned arbitrator, who was a retired judge of our court, he has retired from the brief and therefore have come before my lord for appointment of an arbitrator. Since there was a previously retired honorable judge of the court, I would request my lord, we will make a appointment in like nature or senior advocate, but my lord, I would request if it's a retired judge of this court.
What is the dispute?
My lord, I do not wish to enter into the nature of the dispute.
Yes.
My lord, the nature of the dispute is there was a tender process which had happened. During the tender process, a corrigendum was issued. According to me, it was unilaterally issued at a belated stage, and the scope of the work was reduced, from which this was a tender for the purpose of taking out scrap and breaking down or dismantling of a particular plant and machinery. So because of this corrigendum, the scrap material which I was to recover, the amount was reduced, and there is certain dispute with regard to the time period within which, the 28-day time period within which I claim that there was an extension. Their point is that it had expired and I am liable to pay penalty on that. So this is the nature of the dispute, my lord.
And Lordship, there was a counter claim also, Lordship, because the work was not done within a particular period of time.
My lord, if my lord is
there was a APCOM filed.
yes, my lord. That is the APCOM is the section 11 application, which is order is at page 51, my lord. This was for appointment of the arbitrator itself, my lord.
Take down. Petitioner has preferred the present application under section 11(6), read with section 15(2) of the Arbitration Conciliation Act 1996, seeking appointment of substitute arbitrator in place of Honorable Justice Prasenjit Mandal, retired, whose mandate has been terminated during the pendency of the arbitral proceedings. Full stop. Learned counsel for the petitioner submits that this court, in an earlier Section 11 petition being APCOM 659 of 2024, while order dated 27th August 2024, had appointed the learned sole arbitrator, Honorable Justice Prasanjit Mandu, as the sole arbitrator to adjudicate the dispute between the parties. First one. Pursuant to the said order, the learned arbitrator had entered upon the reference on 10 September 2024 and the arbitral proceedings commenced. Full stop. It is stated that the pleadings were completed on the 7th sitting held on 12 June 2025 and thereafter the proceedings continued on several dates. Full stop. According to the petitioner, by the 20th sitting, substantial progress had been made and the proceedings had reached the stage of recording of
Cross-examination.
evidence.
Cross-examination.
Full stop. Learned counsel for the petitioner further states that during the 21st sitting held on 20th May 2026, the learned arbitrator recorded that the learned advocate appearing for the respondent had expressed lack of faith in the traveler and advanced submissions which the learned arbitrator considered inappropriate. In view thereof, the Honorable Justice Prasanjit Mandu recused himself from the arbitral proceedings and terminated his mandate under Section 15(1)(a) of the Arbitration and Conciliation Act 1996, observing that the parties may approach this court for appointment of substitute arbitrator. Learned counsel for the petitioner states that in view of the said development, he has approached this court under Section 15(2) of the Arbitration and Conciliation Act for appointment of a substitute arbitrator. He further states that since the arbitral proceedings have substantially progressed and have reached the stage of cross-examination of the petitioner's witness, early appointment of a substitute arbitrator is necessary to avoid further delay and prejudice to the parties. Learned counsel for the respondent states that he has no objection to the present application and further states that an arbitrator can be appointed for adjudication of the dispute between the parties. This court has reviewed the material placed on record and has heard the parties. Full stop. The record disclosed that by an order dated 27th August 2024, passed in APCOM 659 of 2024, this court had appointed Honorable Justice Prasanjit Mandu as the sole arbitrator, holding that the appointment procedure contemplated under the arbitration agreement was unforeseeable in law. Full stop. It is also not in dispute that the learned arbitrator had entered upon the reference and conducted the arbitral proceedings for a considerable period. From the proceedings recorded by the learned arbitrator on 20th May 2026, it appears that the learned arbitrator had withdrawn from the reference and his mandate has consequently terminated within the meaning of Section 15(1)(a) bracketing of the Arbitration and Conciliation Act. In such circumstances, Section 15(2) of the Act mandates that the substitute arbitrator shall be appointed according to the rules applicable to the appointment of the arbitrator being replaced. Since the original arbitrator was appointed in terms of Section 11 of the Act, this court is competent to substitute the arbitrator to continue the arbitral proceedings from the stage at which they presently stand. In view of the aforesaid, this court is satisfied that the requirement of Section 11(6) of the Arbitration Conciliation Act stands fulfilled and the present application deserves to be allowed. Accordingly, Mr.
I would recommend Justice Shamapti Chatterjee, a retired High Court judge.
Justice Shamapti Chatterjee, give the details. Is appointed as the substitute arbitrator to adjudicate the dispute which have arisen between the parties. The learned arbitrator shall make disclosures as contemplated under Section 12 of the Act before entering the reference, upon the reference, and before entering the reference. She shall be entitled to her remuneration in terms of the fourth schedule of the Act or in accordance with the consent of the parties. All questions on merit expressly are kept open to be adjudicated by the learned sole arbitrator. The present application is disposed of.
My lord, I should make one disclosure, my lord. My lord has recorded that under the rules, the new arbitrator can be appointed. My lord, the rules initially had indicated that a nominee would be appointed by the respondent. Since that is under section 12 now, that is not the right position. So therefore, the appointment was done under section
That
11.
was done in the first round of appointment itself. What was contemplated in your provision had already been given a go back.
Yes, ma'am. Yes, ma'am.
First order.
Well, I thought I would indicate that to ma'am.
And why are you misbehaving in front of the arbitrator? You are the lawyer.
No, Lordship, it was my senior Lordship. It was an allegation. I'm very sorry
Very
for that,
unfortunate.
Lordship. But it was being constituted and transpired in that case, Lordship. I'm very sorry for that. I bow down to that, Lordship.
Excellent. Time case already ongoing arbitration. Short one. That's good.
Adjourn motion item number 24.
Yes.
Lord, this is my petition. There are two petitions, my lord, under section 11 of my lord, the Arbitration Conciliation Act. My lord, the contested one, my lord, on the question of my lord, jurisdiction.
Yes.
My lord, there is a forum selection clause, my lord, which is there in the agreement, and my lord, there is a seat clause as well. So, my lord, I am saying, my lord, forum selection would prevail over the seat clause, and my lord, therefore, Kolkata will have the jurisdiction. And my lord, my learned friend, my lord, is urging that, my lord, by reason of seat, so it should be Delhi. So I don't want to go to Delhi, and my learned friend doesn't want to, my lord, stay in Calcutta. So that's one of the that's with the situation. Because I filed a section 11 earlier. My lord, this is, my lord, a lease agreement which was entered into. My lord, I am the head lessor, so to say, my lord. I gave a sublease, my lord, to Amazon.
The pleadings are completed.
This is for the warehouse. Yes, my lord, has to be heard, my lord.
We filed notes and compilation of cases also, which are on record.
So we'll hear it today or in view of your resolution?
Yes, my lord.
If
No, there is a resolution. That's the.
If are not there, then we'll not. I've
I'm
already run into rough weather in the morning, but doesn't matter.
My lord, I've always been against, my lord, taking this resolution, my lord. I'm always been very clear. But, my lord, since there's a resolution, my lord, I think, my lord, I can, my lord.
As you feel, I have no problem.
When do you want?
Tomorrow,
Day after tomorrow?
whichever is convenient.
Day after tomorrow or whenever.
Whenever it's convenient.
Whenever it's convenient for both of you. Just
I
my lord. Yeah. My lord, next week, Monday, my lord, if it's possible, my lord. Like, Ashish.
May I request? I request for a little priority since my lord.
Yes. My lord,
I have a claim, which is my lord on this nice question of law.
I also have a claim.
I have a better claim.
My lord, he terminated and went away to 10 years lease. He terminated, went away, he was not paying me rent. He says, I don't want to pay you rent because there's structural damage. My lord, that doesn't, my lord, absolve him from rent obligations, payment of rent obligations.
We'll have it on Monday. It's fine.
That's some priority.
Today also it reached?
Yes. Same.
We'll maintain its position.
Grateful.
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 I'll record one line, Mr. Banerjee.
Yes.
Just in view of the resolution, let this matter be listed on Monday. In view of the resolution passed by the bar, let this matter be listed on Monday for our
But we've also included, Your Lordship's judgment in Salty, which we cited, in the compilation. I think it more or less looks at the issue.
There are some judgments which my lord has to consider. Grateful.
full. 25.
24, 25 are connected.
26. Because the একটাই order হবে।
Yes.
Today is fixed for receivers report. She was right here.
She's here. Yes, what is your report?
Alert. This is my report.
Yes, it could not be taken because it didn't match the. Probably it has been changed, but
Another asset was there and other parts also changed. If the petitioner wants to look into this and arrange a visit again sometime later.
what about your section 11?
We are filing. We have filed in few matters and we have filed actually. It will be listed sometime.
Learned report filed by the receiver is taken on record. Learned counsel for the petition seeks and is granted time to peruse the report. She prays for an adjournment. Let this matter be listed after. When do you want? 4 weeks? 3 weeks?
6 weeks.
After 6 weeks. 6 weeks.
Yes, 27.
Yes, Ms. Sen, what's the report? Pick up.
If I'm seeking for an extension. She wants to be discharged, may another receiver be appointed.
Discharge? Why? This has been paid. Your invoice has been paid. This has been paid.
Lordship, travel expenses have been paid and remuneration have been paid. She is asking for the preparation of report, whatever expenditure she incurred.
Paid and finished off.
For the preparation of the report.
Not preparation, stationery and all that.
Remuneration and travel expenses have been paid.
They have not been able to take it because I think probably it's lying with the sales
GST department.
GST department. So what do you want to do now?
Lordship, they are trying to ascertain the situation and find out a way to get the asset.
So why should this be kept pending?
Lordship, sometime may be given.
For what?
Lordship, if they can get it released from the GST
So that's a
department.
separate proceeding altogether. The GST commissioner has probably taken the vehicle.
Lordship, I'm waiting for the instructions from the client. They asked me to seek for an extension. If he wants to be released, may another receiver be appointed.
The receiver for what purpose?
Lordship, once they can find a better particular.
You come back after 2 weeks. Let her be there. Learned counsel for the petitioner prays for an adjournment. Let this matter be adjourned for a period of 6 weeks. We'll see after 6 weeks. Sort it out, otherwise withdraw that and section 11, file a section 11.
We have filed the section.
Next.
28.
Yes.
I think the last two orders. One is
Wait.
Your Lordship, I'm praying for a not today, Your Lordship.
Who are you?
Your Lordship, for the respondent, Your Lordships, I am being led by Miss Anamika Pandey, Your Lordships. She has certain difficulty, that is why I was praying for not today. Just
You were exploring a possibility of amicable settlement.
my
What
lords,
happened?
it failed, Your Lordships.
Why you have not paid the remuneration, madam?
last I told the teacher also. Lordship, she's not the receiver. My lord. No, I'm the receiver in this.
APCOM 49.
Yes.
This is APCOM 45. This is 45, madam.
45.
This is 45.
45.
Yes.
And Lordship, she has been paid. We sought for an extension in the matter and then we withdrew the
We'll
matter.
see that later. Yes. What happened in this?
Lordship, the settlement talks failed. They paid one installment and then they failed to pay the rest. And we waited for.
There's no section 9 in this.
Yes, Lordship, there's section
We
9.
had already attached. What is attached? What do you want today?
Lordship, I'm praying for an adjournment. We will get the mediation minutes and then.
All right. Learned counsel for the petitioner seeks an adjournment. Learned counsel of the party is seeking an adjournment. Even he wants an adjournment. List after. When do you want?
Next week, Lordship.
After 2 weeks.
Wait.
Obliged.
$29.
Right.
We are consenting to go to arbitration. Section 9 petition. Yes, for arbitration, but provided that it's composited. The parties are different in 29 and 13. But it's part of a singular transaction. Pleaded that also affidavit complete.
Who's here?
Was
Not here. None for the petition. In the interest of justice, adverse orders are deferred. List after. Like, well, not today, girl. Keep it on Wednesday.
May I only pay for this? Daily, because it's really for
Daily list, yes.
But this is the monthly list today on Wednesday for it. It is in the daily list. That's my only. But like,
My lords, this is that MSME Facilitation Council matter, my lords, where our remedy has become, where my lord, our remedy has become ineffective, my lord, because the council is not taking up. Last time, Mr. Ganguly again made a statement, my lord, that council has given some communication which my clients have not received anything. And since the last date also, my lord, no orders have been passed. No communication has been received from the council. My lord had asked, we are filing a supplementary affidavit in this regard. My lord had called upon him to address on the merits of the matter, at which point, my lord, he informed that the council...
I can't pass
No,
any.
let it, my lord, be in the list, my lord.
Not today.
Yes. My lord, while instructing colleague is saying that will it be in the, my lord, can it come in the daily list, my lord, Wednesday?
Keep it in the daily.
Okay.
Not today. Nobody is here. No adverse orders.
My temporary application.
Not today.
Means this matter because as you indicate, the limited instruction they have to seek was whether they'll.
They're not here.
No, you logic attending the daily list. That's it.
Keep it in the daily.
34. My lord, this is that section 9, my lord, application, where my lord, my learned friend has raised an objection, my lord, saying that it is not maintainable. My lord had in fact passed an order at the ex parte ad interim stage, granting and direction that.
Respect my learned senior colleague. In the resolution of the library club.
Yes.
The 3 members are trying to a little reluctant to do the matter.
No, if they don't
Can
want
it
to,
be-
no difficulty.
No, Lordship.
Not today. Not.
My learned senior colleague is also.
Not today.
My lord, can I make the same request in this?
Monthly daily list. We'll see that.
I apologize.
Most.
35.
Who's there in 35?
35.
Not today.
That is 6.
Not today.
37.
This is that, my lord, simplex matter, my lord, I commenced my arguments.
Not today.
Daily list, my lord, can it be?
It'll be in the monthly list. What's the urgency?
Because there's some urgency, my lord, section 9.
Is section 11 pending?
Section 11 also. This is section 9, my lord.
Where's the section 11?
Section 11 is not, it's filed, but it's not filed. It's not yet filed.
Why you have not filed? No urgency.
21 application has been, 21 notice has been sent afresh. My lord, it is already, my lord was hearing arguments, my lord. This is that matter, my lord.
38.
Our 69 application, but other side is not to.
Not today.
I appear for the petitioner.
You're doing it?
So I can, Lord, if they are ready, Lord, I can. That what had happened, Lord, on last occasion, Lord, this is an MSME arbitration. So arbitration has commenced. They had taken a point essentially, Lord, that since the arbitral tribunal has been constituted, that is the MSME council. So therefore, Millard, section 9, Millard, will not be applicable. We should go to section 17.
May I just say this candidly? If your lordship is minded to because in item number 31, a similar thing happened. We went to section 17 and thereafter nothing happened. Thereafter, we again had to come in the section 9.
But that can't be the case.
Yes, I appreciate that, Millard. If your lordship is minded to, Millard, hold that we should go to section 17 first, Millard, I'll withdraw this.
You should.
I will file 17, Millard. If it is not efficacious, Millard, I
Will you come back?
Yes.
Learned counsel for the petitioner seeks to withdraw the present petition.
They had indicated in February, perhaps, Millard. I have taken note of that.
Learned counsel for the petitioner seeks to withdraw the present petition. Since the tribunal has already been constituted, full stop. The present petition is dismissed as withdrawn.
But with the liberty to
file appropriate proceedings in accordance with law.
deeply appreciate.
Your lordship, my application under section 9.
Not today.
Not to your lordship, may I just indicate this is actually there is some urgency because 5% of the work is left. It can be there tomorrow. I cannot press for it obviously. On Wednesday, your lordship. I apologize. It can be there on Wednesday. Grateful. Great.
What do you want?
I would have renewed, Millard, my prayer for resolution, but I think the special officer is here. He has to file a report. Let these compliances be done, recorded, but let the matter be taken up tomorrow, Millard.
What is it?
This is my section 9 application. Lordship was pleased to appoint a special officer. He has visited. He is filing a report.
From the bike showroom. The bike showroom, the respondents are instructed that they have surrendered their dealership, and also the fact that this property was a tenanted property and they've given the allegation is they've given back the possession, but on the report what will be reflected is that there are furniture and fixtures there inside the bike showroom. So I have indicated that in a detailed inventory signed by all parties.
I've already served.
Report filed by the receiver is taken on record. Full stop. Affidavit in opposition filed by the respondent is taken on record. You want to file?
Millard, kindly keep it on Wednesday, Millard. For me to make arguments today, I'm a little reluctant to do.
You want to file your reply to this?
Yes, your lordship will direct us to file
Learned
it.
counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the affidavit in opposition. Left after 3 weeks. What is it?
Well,
You be here.
oblige.
Something. 42.
Not today. Not today.
On behalf of the private.
Not today.
45.
Not today.
What is 6?
Not today.
47.
Not today.
48. 49. 50. 51. 52. 53.
Item number 54.
Your Lordship, I'm being led by Mr. Banerjee. If you can get a short. You can get a
55. 56. 57. 57.
You are there, Mr.
Nine application, my lord.
Not today.
58.
58. Arbitration section. Some urgency. Not today.
59.
59. I'm being led by my senior, Mr. Shuddhashatta Banerjee. May I pray for a not today?
Not today.
Grateful.
60.
Section 9. Not today.
61.
Not today.
62.
For application, my lord. Not today.
63.
Lordship in 63 also same order.
64. 65.
Respondent or the petitioner? Not today.
66.
66. I intend to move this ex parte identity, my Lordship.
Not today.
67. 68. 69.
My lord, 69 to 70 is the first time it is appearing. There is no other side, my lord. I don't know whether the
Whatever it is.
69 to
Therefore.
75 and 89 are all similar matters.
Not today.
We are praying for, but it's a fresh matter, has not been taken up, my lord. Can this come in the daily list? Because it's not a hearing matter, my lord. It's coming up for the first time, my lord.
No daily list.
New motion.
We'll see. Let it be in the monthly list. All section 9s.
All section 9, my lord. Yeah, and 89 is a connected similar matter.
76. 77. 78. 79. And now 80.
बस हो गया. There's no point calling out the matters. Bolo.
My lord, just one, if it, with your lordship's permission, this item 89, my lord, this is similar as 69 to 75. Can it just be taken up together? Or because it's the same, the petitioner is the same, similar matter. Yes, madam.